Hi, everyone. Thanks for joining us. The Comparative Law Association is honored to have with us today Professor Santiago Legarre, a leading expert in jurisprudence, international law, and comparative law. Professor Santiago received his law degree in 1992 and subsequently earned a master's in legal research from Oxford University and a PhD from Universidad de Buenos Aires. After law school, he clerked for the Argentine Supreme Court and thereafter started his teaching of law. He has been published on numerous journals and is currently a visiting professor at Notre Dame and Strathmore University in Kenya, which is where we met. He has been invited by Columbia, Harvard, NYU, amongst other universities, to give lectures ranging from topics on natural law to questions on teaching constitutional law across 3 continents. Professor Santiago is a man of many talents and often pushes the boundaries of what it means to teach law. Without further ado, help me welcome Professor Legarre.
Thank you so much, Nemo, for that very kind introduction. Perhaps you don't know that Nemo comes from a family of artists, and our first interactions go back to when she was 18 years old and a law student in Kenya, where law is an undergraduate degree. And sometimes her younger sister, who was 10 years old and is now a renowned pop singer, like you turn the radio in Nairobi and you have her sister singing. I knew this little girl could sing, so I would ask Nemo to bring her to school, and when she and her friends at the law school were tired of listening to me, sometimes I had the small sister, Nikita, in case you want to look her up, sing for us. And it's beautiful to see her now and for the first time. I brought from Kenya. This is my first time speaking here. Time if I manage not to break anything. But my rapport with your school goes back, if I may indulge in telling you before I get into my topic, to when I wrote my dissertation in Oxford, and when I finished it, I was instructed by my American friend. Now I probably wanted it to try to get it published in the United States, as it was on a U.S. constitutional law topic. And then I was introduced into this not so fascinating world of law reviews and law journals, and this extreme notion of simultaneous submission, with which I was very unfamiliar, as in my part of the world, Argentina, like in Europe, you submit an article, a draft to a journal, and you need to wait until they tell you yes or no, before, if they tell you no, you submit it to a different journal. But, my friend said, we have Scholastica, and here you have 400 boxes, and you can tick which journals you want to submit your article to. The bad news is you are in Oxford, you are not a faculty member at an American law school, so you'll have to pay $5 for each of those submissions, which in those days were actual submissions in paper. So I wouldn't tick the 400 boxes as the random American law professor would do. I chose some. I chose the University of Pennsylvania Journal of Constitutional Law and a bunch of others. And I heard back from many, and it was nice to see there was a consistent thread. They all said no, 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 no. We receive 5,342 submissions each year, Stanford said, and we extend 22 offers. Unfortunately, your work is extraordinary, but you're blah, blah, blah. Anyways, I was devastated as I didn't know this business. So they told me, wait till the fall, try again, the spring submission cycle is over for you. This is my friend. So now I'm back in Argentina, and I try again. And maybe there is something to be said for that notion that sometimes you succeed in your third attempt at something, because I again got no's. Now in the third attempt, Brigham Young in Utah gave me an offer, and they gave me 1 week to decide. I thought, why do I want to wait or decide? I have to reward these brilliant young guys in Salt Lake City with an acceptance. But my friend said, no, you don't do that. Now you request expedite review to Penn, to everyone else, and then if you get, a better offer, you take it and you write to the guys at Brigham Young and you say, no, thank you. And I thought, this is so cruel. This can't be real. And this is how I got the attention of this journal. I was walking today around, touring myself to the building, and I saw Journal of Constitutional Law in one of the doors down the corridor. And I thought, wow, this is the guys who, 15, 17 years ago, extended me that offer and then made me feel very proud, very honored, and very guilty with the Brigham Young crew. I wrote to say, guys, I'm sorry. Only later down the road, I had maybe 17 more articles published in the US since then. Only later down the road, I learned that the law review students have no feelings, or at least they don't get hurt by any of those rejections of offers, as it's part of the game, part of the deal. So I've just done it again. I've just killed 2 schools again who extended me offers and allowed me to gain some time, go to higher schools, and eventually got a better offer. But now, I guess I'm part of the, the band of assassins that in cold blood managed to write emails without, feeling bad. That was supposed to be a joke, by the way. It's so difficult with humor when you don't know you're proud, especially if they don't know you. And I don't tend to laugh when I tell a joke. I don't like people who laugh at their own jokes. You see, that was another joke. Down to 0-2. I want to make 2 simple statements. I'll talk for about 20 minutes or so and then open it to questions. I know that the most important part has happened already, which is that you've been fed, although Bianca says that there have been other events with feeding and not such a good turnout. By the way, thank you so much to the Association of Comparative Law and to you, Johnson, for this invitation, and of course, again, my 2 simple statements are that international law is law and that comparative constitutionalism is not law. Now, they may seem as simple as saying that wall is a wall and this table is not a wall. But not so. Sadly, these 2 statements are very controversial these days. Sadly. So, international law, sadly, is considered not law very often. And we will see briefly today one context in this which happens that international law is not law. And this context has to do with comparative constitutionalism. And secondly, sadly, comparative constitutionalism is treated as law often today. And I'll start here. I'll start with this second eternal confusion. A confusion that is reflected on the name of your club and on the name of the typical class you find in the top 30 law schools, comparative constitutional law. But I just said this is a mistake, which is why I will argue we're better off to get rid of this name and call those classes and your association something like comparative constitutionalism, so as to avoid that the label itself will misguide crowds to the wrong conclusion that it is law we're studying the same way contract law is law or property law is law. Comparative is not law. No, comparative is law, and comparative constitutional is also not law. Now, why is it called law? Perhaps some of what I'll say may or may not shed light on that. What is instead comparisons? What is comparative constitutionalism, if not law? Well, I would like to suggest, and I'm in very good company, that it's a type of guidance or instruction or direction, not so much akin to law, but more like a persuasive kind of guidance, unlike law. You know, law backed by sanctions, none of that. And when it comes to Carey. And a better name for it, for this type of guidance, is a methodology. A methodology where you start with your own legal system and you borrow, the verb borrow and the noun kind of borrowing are the crux of comparative constitutionalism. So you borrow, you don't just borrow with any other jurisdiction, but with those that have more empathy and affinity with yours in order to try to learn better from yours, to seek inspiration in the foreign. And this can happen fundamentally at two different moments in political reasoning. One is before enacting some law, before enacting authoritative guidance backed by threats, you may seek a broad inspiration like the founders did with the Constitution of the United States or of Argentina. We, in fact, sought that inspiration in the United States, whose constitution had been out there for not many years when Argentina, the third oldest constitution in the world, had its own. This we could call pre-legislative comparative constitutionalism. Can be before a statute is passed or before a constitution is drafted. So pre-legislative or pre-constitutional. And it happens in an assembly or in Congress or in a constitutional convention. Now, the likes of Justice Scalia, for example, in his very famous 2005 television debate with Justice Breyer, I mean, it happened in D.C., but it was broadcasted nationally and made the front page of every newspaper back in the day. He who thinks comparative constitutionalism is silly and pointless, and I will disagree with this, he instead is very open to the pre-constitutional or pre-legislative use of foreign materials. The problem for him, and this is where he parts company with Justice Breyer in that debate, and then in the capital punishment cases you may be familiar with, where Chief Justice Rehnquist and Justices Thomas and Scalia dissented from the majority, that was not at a pre-legislative or pre-constitutional moment, but in adjudication, when you are writing a judicial opinion, and now you're bound by your law, by that legal, authoritative guidance, and the question is, am I allowed to use foreign materials in any way when I am exercising the judicial function? He would say, never, as so does, in an antipodical ideological point of the range of ideology, Judge Posner, who is also completely against any use by the judiciary of foreign sources, although he would disagree with Justice Scalia about almost everything else. And instead, the majority in that case, the moderate justices then in the Supreme Court, in opinions written by Justice Kennedy, joined by the liberals, and Justice O'Connor and Justice Souter. They would say, yes, we aren't bound by what the Constitutional Tribunal of South Africa or Germany, Karlsruhe, would say. We aren't bound, but we are authorized, and indeed it's good if we engage in trying to understand some decisions that are relevant for what we have in our hands, in those cases, whether capital punishment as applied to juvenile delinquents or to people who had some kind of disability became unconstitutional. So they would look abroad and they would search for a consensus based on some universal values. Basically, Justice Kennedy says that this is good so that we can confirm if our national solution is ridiculous or reasonable, so that we can receive instruction. So again, it's a way of learning about our own. And I think that this is good, that this is important, and this is why I think it's also good to teach it in law school. In other words, I agree with them that it would be a regrettable provincialist judicial attitude to be completely locked to the world. And one could add, especially in our days of a global world, but up to a point, because this was even so in medieval Christendom, where you also had, even more than now, universal legal tendencies. Some were disastrous, some were good, under the word of jus gentium, but they were universal anyways among the people. That's like the prequel of international law. The problem is that, sadly, this methodology, praised by the majority of the court in those cases, and humbly by me today, has been transformed sometimes into ascribing the foreign source legal authority in my jurisdiction so that I can change through judicial fiat what I cannot achieve in the legislature or through constitutional reform. So because I can't do that domestically, I borrow, but I don't borrow to seek confirmation. I borrow to substitute what I don't like of my own law or of my own constitutional law. Hence, the term comparative constitutional law applies well to this manipulation of the foreign source. So there could be two courses in law school. Comparative constitutionalism, where you teach people about the good side of the moon, and then comparative constitutional law, when you play Pink Floyd and teach them the dark side of the moon. Let me give you an example of the dark side of the moon in Argentina. But believe me, this is one of 100. And the devil in my example, but not only in mine, is the United States of America. You perhaps won't be surprised. We have a constitution, as I told you, that is inspired in the US, but in one topic. We did not have a history with a country like England or Britain, like the one that your country, the country for some or most of you, had. And therefore, we don't have an establishment clause, which was seen in America in 1787, 89, as an important thing to bridge a wall with the past and with the islands. Instead, in Argentina, instead of an establishment clause, Section 2 of the Constitution, like at the very beginning, says that the Argentine state supports the Catholic religion. Now, what that means has varied through time and it's disputable, but what is very clear is that that is very much at odds with an establishment clause of any sort like the one in the First Amendment of the United States Constitution, to the United States Constitution. Nevertheless, when we had a horrible economic crisis some 25 years ago, and the government kept the bank deposits arguing emergency, more or less, like I was in oral argument on Tuesday at the Supreme Court. I wasn't the Solicitor General or anything. That was another joke. But I was attending argument, and it was all about this, emergency powers, but that's the COVID emergency. In Argentina, this was a financial crisis, like 200 points of inflation in 1 month. Here in this country, people are worried, rightly, because of inflation, and it's like, what? Nothing compared to that. So the government issued this package of measures, and they seized deposits, and people would go to the banks to get their money. You get it in 16 years. We give you a bond. You put in the bond in the bond market, and they gave you 20% of the face value, a disaster. Some people needed the money for a surgery, some for a trip to Disney World. So the really dramatic ones, they would go to the courts and say, I want to talk to the district judge about my case. No, the district judge has 3,000 cases like yours. It's impossible. Then the guy would pull a gun, put it to his head. This was seen by my friend who was working at that court right there, and would say, I blow my brains if you don't allow me to talk. So in this very dramatic context, some Catholics decided to start a daily rosary in the main hall of the Supreme Court building, a huge building. And off the record, the Supreme Court allowed them to place an image like this, and some people would meet and pray there. An NGO, an American NGO based in Buenos Aires, with funding from some companies in the United States, including Ford, sued the government for having allowed the placement of the image in a public space, in a public building. And the guy who wrote the action, the brief, clerked with me in the past and at the Supreme Court. We knew each other, so I wrote to him and I said, would you mind sharing with me, there, and especially in those days, those documents weren't public. He kindly gave it to me, and this was basically what the brief said, which was swallowed word by the district court that ordered the removal of the image. Number one, in the case of Lynch v. Donnelly, 1972, the Supreme Court decided that a nativity scene could be legitimately placed in a public square because a nativity scene has an independent secular purpose. Number two, unlike the nativity scene, the image of the Virgin Mary is merely a religious kind of image and cannot serve any discernible independent secular purpose, which, by the way, I think is very true. Number three, therefore, the permit for this image to be there, for these people to pray there, is in breach of the Establishment Clause. Now, you may think that this is a joke, because you may think we were talking about Argentina, and we were. But this is comparative constitutional law, or the manipulation of the foreign source in order to achieve what you can't through majoritarian elective procedures, change the constitution, change the law if you don't like it. And sure enough, this judge treated Lynch v. Donnelly as if Lynch v. Donnelly was the law in Argentina, which surely it isn't. So this only as an example of how reform is going about all around the world. You can go about ideologically in one direction or in the opposite direction, depending on what it is you want to reform. If you want to reform pro-life institutions, what you may bring from abroad and try to make it happen judicially will be pro-choice precedents. If you want to reform pro-choice precedents and you don't manage because you don't have the majorities, you find the right judge and you bring the, and so on and so forth. So this is the first confusion that has led comparative constitutionalism to be treated as law in many instances. Now on the second one, in what sense has comparative constitutionalism helped international law to become not law? And with that, I wrap it up and I turn it on to you. Justice Kennedy, in Graham versus Florida in 2010, a follow-up to the big capital punishment cases that I mentioned with other names earlier, Atkins versus Virginia, Roper versus Simmons. In this third one, when he is reiterating the idea that we are allowed to engage in this international conversation, borrow, respecting boundaries, restraints, respecting our law, as he's doing this, in one and the same sentence, he's referring to those foreign sources, say a precedent of the Constitutional Tribunal of South Africa, and to international agreements that have been signed by the United States. In other words, treating international agreements as if they were not law, in the same way he rightly understands that foreign law may be law abroad, but it's not law for us. So by doing this, maybe inadvertently, he's confirming a very old, derelict, abandoned approach to international law that has been famously or infamously summarized with the idea that it is aspirational law, not law really. You know, I saw a plaque, someone in my tour, beautiful plaque on international law by some alum, and I was thinking, well, if he knew. Because, you know, if you treat international law like you treat a methodology, like you treat persuasive language, persuasive guidance, then of course, whenever you don't like, whenever you are not persuaded, you will do with it what you don't do with your law. You will leave it aside, which is sadly what has happened in many instances in the history of this country, and in generally of all the countries that have power, because only the one who has a lot of power can indulge in dispensing with international agreements. If you are poorer, if you are weaker, you don't want to do that because you know that then you won't have anything to offer because you don't have money. So you need to keep your trust. But when you have the money and the power, you can play this game of the aspiration, which is not altogether different from that other game of considering constitutional law itself as an aspiration. When I finished law school, and I finished now on this note, when I finished law school, I wanted to teach. I was clerking at the Supreme Court in Argentina, but I wanted to teach part-time a bit to discern whether afterwards I would like to try to pursue a teaching career. And the way we do it in my country, where normally you go to law school in the same city where you were born and you went to high school and all that, is you approach your favorite professor and you ask him if you can be a teaching assistant. I mean, this happens here too, but there it's very clearly the path. And I had two guys I could go to. One was the con law person, and the other one was a guy who taught corporations and black letter law. And I hesitated a bit, but in the end, I decided to go to the constitutional law guy, and then I always stuck to that down the road. But like 6 months into my mini law teaching experience where I would go to law school once a week for 2 hours and sometimes do a presentation or help the prof. I met the corporations professor in a corridor, and he remembered me because he was one of my favorites. You know, your favorites, perhaps they also remember their favorite student. So he said, "You're here, you're teaching." You know, I could sense even in my hope maybe a slight disappointment. And I said, yes, I blushed, and I told him the truth. Yes, I'm doing constitutional law. And this is what he says. It summarizes with a joke, again, most of what I told you in the last 5 minutes. He said, "That's excellent, you know, congratulations. When they tell you that, you just wait and hear what comes next." He said, "The only thing is, I'm really sorry that we lost you for the law." This same idea, constitutional law, morality, persuasion, international law, completely. Thank you.
Thank you very much. I think we have time for a couple of questions, so if anyone has any questions.
I can go first. Thank you so much for this. This was quite illuminating. While you were speaking about the first point, I was just thinking about how over the last few years there's been a rollback on democracy around the world.
Speak a little bit louder.
Yes, of course.
Thank you so much.
Can you hear me now? Okay. So I was just thinking about how over the last few years there's been a rollback on democracy around the world. And as a result of the vacuum which has been created in many countries around the world, the judiciary has often stepped up, you know, doing a sort of judicial activism. And regarding your first point that you were talking about, I was just wondering that when in countries such as that, where there's a lot of political instability and the human rights regime is not very, very strong, the judiciary often uses, as you correctly pointed out, comparative perspectives to try to make the law where it isn't quite so. And in doing so, you know, oftentimes they expand rights of women, religious minorities, into spaces where the legislature, for instance, has not forayed into. So over there, do you see comparative perspective as being a necessity? Or do you still think that it signifies a sort of institutional decay and therefore should not be, you know, approached? I was just wondering what your perspective on that would be.
I think that similar to what I listened to in the Supreme Court on Tuesday with the COVID emergency, and similar to the financial emergency I mentioned, when extraordinary circumstances like the ones you mentioned, and they are extraordinary even if they recur, obtain, then some of what I said needs to be changed. And I would agree and I would concede that what I have been lecturing about or arguing for is for normal circumstances of a country that has a rule of law, that has a fair constitution with respect for minorities. But when all of that, to borrow from you, decays, then it's not decaying to use foreign law in a more aggressive way than the one I was referring to. That's how I would see it. You see, what I resist is this notion that in normal circumstances, whenever you can't achieve it through the ordinary process, you just find a judge who's game and who studied in Yale Law School. It's typically how it happens in Argentina.
When judges use foreign law as actually binding law, I mean, how do they justify that? It just seems so inherently wrong. Have there been challenges in lower courts to this practice?
Oh, it's very easy. They have been trained in law school, like law schools like the one I mentioned, or maybe Penn law, on the notion that law is a feeling of justice, or something like this. Otherwise, you are a formalist. You are the devil. You are Amy Coney Barrett. You know? Law instead is to make justice, and whatever works is fine. And what is justice? Well, ask me and I'll tell you, they'll say. Because, of course, once you get rid of the legal system, of the norms, of forms, you have as many justices as persons. So now, what do you get in law school? You get, in many law schools, you get just a bit of law, and then all sorts of things. In the past, therefore, you went to law school. If you had an engineering mind, but you were bad in math, then you go to law school and you won't be bored, because it is boring, but you're like that. But these days, the imaginative person who never would have gone to law school in the past finds home and creation in law school and in law. Critical legal studies, economic analysis of law, you name it. Yeah.
There was a question over there.
So I think the answer you just gave gets into the judicial psychology of comparative constitutional law. Like, why are judges going to foreign sources to try and get the rulings that they want to get? But what I'm still curious as to, publicly, not privately in their own minds, but publicly, is there a common trend in the rationales that judges across the world are using to justify using foreign supreme law to interpret their own supreme law? Is there a common thread into how judges are grafting foreign law into domestic law?
Thank you. These are very useful questions for me to think this through. I would say there is another irony here, because, of course, a judge doesn't need to explain the way they would need to explain if they were in a classroom. But the thread you can pull is, well, if this is about a common sense of humanity, of shared values, of the fact that we say, Americans or Argentines, we are not unique, we are the same, we're persons. Then the details, the law, where you take it from, it doesn't really matter so much. Which is why, they wouldn't say it like this, but this is what I pulled. Which is why the common denominator is that there is more recurrence to foreign law, precisely where it could be argued that there is more in common. So when it comes to the way power is structured, you have less resort to foreign laws. When it comes to rights, to fundamental rights, you have more. And it does make sense to me. Of course it does. But even when it comes to fundamental rights, my dear professor of corporations is wrong. There is law that is different in different jurisdictions. In some countries, you do have freedom of expression against a private party. In other countries, you don't, just to give you one example.
I just wanted to add on to that. Like, one of the things that I've noticed, I'm wondering if your experience is the same, is that oftentimes domestic law can be manipulated, and then, you can also interpret international treaties in a certain way, and then you can use, after you've done that legal jargon sort of thing, you can use foreign jurisdictions as a bolstering point, rather than saying that, you can acknowledge that they're not binding, but at the same time use that to bolster that, the language in that particular country is kind of similar to ours because we share a colonial past, for instance.
What is that? Could you explain that, please?
So, for example, in Pakistan, for instance, a lot of the laws that we have are quite similar to India. Right, so if India has in its constitution or through any domestic law interpreted something in a very specific manner, you could use similar reasoning to say, if their language is so similar, even if the context is slightly different, it does make sense to sort of go in that particular way. So using shared history could be a methodological tool as well.
Yes, I agree with that, and I think if you would keep it with its proper restraints, it makes sense to go to the foreign law, the foreign country that has a shared history with you. So this accusation of Justice Scalia's in the debate that the opposing side, in the person of Justice Breyer, in the debate, are cherry-picking because, he says, they only bring the foreign law, and the foreign law is going to say what they like. So Scalia is saying in 2005 to Breyer, why don't you borrow foreign law in a portion where the vast majority of the countries have a way more conservative stand than Roe v. Wade, which was good law then. And I think he's wrong there, because clearly you will always borrow, as I said earlier, from those jurisdictions with which you have such affinity that will allow you to understand better your system. Like, take, for example, if you are a judge in the United States who has the right notion of law, but still wants to borrow as a source of inspiration, they won't go straight forward, for example, to some jurisdictions with Sharia law or other variants of Muslim legislation that are completely incompatible with their notions of freedom of expression or religion. And I think that makes total sense to me. It's not neutral. This isn't a neutral game, the game of borrowing. Neither when you do it the way the NGO did it in Argentina, obviously, they just looked to lynch Vidal-Only, or when you do it in the right way, you will always look at in the right direction. Otherwise, it will be useless, a waste of time.
Hi, thank you for being here. My understanding is that higher education is a lot more accessible in Argentina and then in this country. Because of that, there are a lot more lawyers. People are more learned about the law and how it impacts their lives. How do you see that reflected in comparative studies and the Argentine law?
Thank you. That's indeed so. The standard joke is that, well, two jokes. One is, remember, law is an undergraduate degree there. One is that in life, we say in Argentina, in life, you shall be what you're called to be, or you will be a lawyer. That's the first one. So it's the default degree and the default profession. I think very unlike a country where it is so expensive to study law, like here. The other joke is that like half of the cab drivers in Argentina are either shrinks without a job or lawyers without a job. So you talk to them and you learn a lot about the law, and indeed, people in my country also, they travel a lot, and I would say, yes, they are fairly knowledgeable about comparative issues. They would feel very comfortable with Bianca's association.
More time for questions. I don't see anyone from the audience right now, so I will pose a question.
Please.
And let me play devil's advocate for a second. As LLMs, we spent basically a month before the school year started hearing about how the US system is so unique and it's unlike any other system around the world, and it's like we made a good choice coming here so we could see how unique it was. So how do you see that juxtaposed with a notion of wanting to do comparative constitutionalism and seeing it as a valid source?
Well, the joke would be that for the random US law student, the US system is unique because it's the only system they know a little bit about. But they don't care much for my jokes. Before coming here, I taught a short course called Comparative Constitutional Law, alas, and we went through the different systems of judicial review. This by way of example. I answer you with an example. These were all JDs, never exposed to anything but the 2 years of law school they had done, where they hadn't seen any foreign materials. Now, after 3 weeks dealing with centralized systems and the German Constitutional Tribunal, where your parents lived, and so on, now they all became romantics, and they said, wow, this is so much better than the US system. So now I had to stop them when they had to write their papers, and one option was to write a paper titled My Favorite System of Judicial Review. I had to warn them and say, look guys, now let's not go from one extreme to the opposite extreme. Now it's not that you all have to be Germans.